hopefully not too many of you tuned out in the first 15 minutes. Sorry about those technical difficulties. My name is David Albert Pierce. I'm the managing partner of Pierce Law Group. And this webinar today, and we will probably do it again, or at least have the video up and recorded for future broadcasts. We may even just do it again if since we had a little bit of a rocky start in the first 15 minutes. Just some basic introductory thoughts that Peter Baxter from Slamdance wanted me to be sure to share with all of you. Slamdance put this together in conjunction with Movie Maker magazine in an attempt to assist the independent film community, let them know, what is available to them, answer a lot of the questions that many of you no doubt share, and know that Slamdance has always been committed to serving the independent film community and working as a family, particularly with those who are directly affiliated with Slamdance, particularly their broad breadth of alumni. Likewise, Movie Maker magazine wants everyone to know that if you are a filmmaker trying to finish a project under these circumstances, especially if you're in post or looking for publicity help, our friends at Movie Maker magazine have a program called Movie Maker Production Services, where they double your budget through partnerships with Movie Maker sponsors. If you have a starting budget of at least $10,000, Movie Maker can double it for you. If you're interested in learning more, contact our new publisher of Movie Maker magazine. That's really bringing the magazine and its website into the 21st century, Tim Malloy, and he can be reached at tim@moviemaker.com, or you can direct message them at Movie Maker Mag. That's at Movie Maker Mag, M-A-G. So with those little introductories, and thank you to our friends at Slamdance and Movie Maker, who Pierce Law Group has had close to a 20-year relationship with both. I think Slamdance actually goes a little beyond 20 years. So what do we want to talk about today? I want to cover, I have a number of your questions that were sent in ahead of time to Slamdance. I hope to answer every one of those. We want to talk about what type of unique problems COVID-19 presents to independent filmmakers. Then we want to talk a little bit about understanding what is this concept of force majeure. Everyone likes to use the term. What does it mean? How does it affect you? We're also going to talk about 3 different common law remedies that, if you do not have a force majeure provision that helps you, there are common law remedies that can assist you in place of force majeure or in addition to it. We're going to talk a little bit about government regulations and how that can play into those common law doctrines, as well as the doctrine of force majeure, and also answer questions about what obligations you will have to your crew members once filmmaking is capable of resuming. So we're going to talk a little bit about OSHA safety laws, workers' compensation and workers' comp remedies, and all of this could not have occurred at a more horrible time, just as the entire industry is trying to understand the new California law known as AB 5, which pretty much converts many people who were previously independent contractors and viewed as independent contractors legitimately in the entertainment industry as employees. And what effect does that have on you in this COVID situation? Finally, we'll talk about some different government assistance programs, which if you haven't already heard about or aware of, we'll tell you where you can find more information, how you can apply to those programs, and answer some specific questions that many of you have written in advance about how those programs work. So if everybody's ready, let's talk about this concept of force majeure. Entertainment contracts, there's, those contracts are chock filled with lots of different legal tidbits. And if the lawyers do it right and we've drafted everything perfectly, our role as a lawyer, I've always viewed in drafting contracts, is to answer the questions, what if? What if this happens? What if that happens? What if that happens? And each clause in the contract is designed to address some foreseeable dispute. And by addressing it in the contract and getting an agreement, the dispute is less of a dispute. If the situation arises, we know exactly how we'll handle it. So your contract is just a series of pre-thought out what ifs and how the parties agree to move forward when those what ifs arise. And often we have what a lot of people have come to know as boilerplate clauses. Oh, that's just boilerplate. And I always tell my clients that there really is no such thing as just boilerplate, because every clause in the entertainment industry can pretty much be written in a pro-artist way, or they call it pro-little guy, because sometimes you as the production company, when dealing with the distributor, you're kind of more the little guy. You're kind of the artist in that role. The pro-production company or distributor or bigger guy method, or a middle-of-the-road language. And, it's quite often when we're dealing with studios, they'll put out the basic, studio boilerplate, and they'll say, oh, that's just boilerplate. But when lawyers negotiate those terms, we'll say to the business affairs, a lot of times, we'll just say Section 21. And before we have to say anything even further, if they're in a hurry to get it done, they'll say, okay, don't worry about it. We'll give you the middle of the road language. I haven't even said what I want. But they know that every one of those clauses is written generally in three ways. Pro company, middle of the road, pro whoever's on the opposite side of the contract that's receiving the contract for review. So there comes to be some of these language, like these standard terms or boilerplate language, which is always just in the contract. And a lot of people don't think twice about it until one of those what if situations arise. And then you look to the contract and say, did we foresee this? And what did we agree to do when we foresaw it? This COVID-19 is a great learning lesson for all producers to not just say, oh, that's boilerplate. Read every clause of your agreement and fully understand what it means to you. And if you don't understand a term, if you don't understand what it's trying to say, ask your lawyer to explain it. And your lawyer should take the time to fully explain it. And if you're negotiating it with another side and the other side doesn't know why it's in there, they just say, oh, well, we've had that language in here for 10 years. I don't know why it's in there. Well, if they don't know why it's in there and you don't know why it's in there, and ideally you talk to some lawyers and they'll tell you why it's in there. But if nobody knows why it's in there, get rid of it. Or let's say, well, what do you think it's trying to address? And let's say it in plain English. So the force majeure clause is one of those boilerplates that's just always in there. And it is a creature of contract. And the force majeure language is designed to say what happens if something beyond either of our parties' control prevents this contract from going forward, prevents the basic idea of what we're trying to accomplish. It's going to slow it down either on a temporary basis or a permanent basis. What if that happens? And then it goes on to say, if one of these events arise that's beyond our control, here's what happens. And the force majeure clause can say, let's just say for the sake of example, in the future, I can guarantee you that pandemics will be in force majeure contracts. People aren't going to just leave it out. But so someone's going to say, what if there's a pandemic? And then the force majeure clause will say, this is what will happen. And it might say this, we're temporarily suspended until the pandemic is over. It might say if the pandemic and the government shutdown orders extend past 60 days, then this contract is considered null and void. And then they'll talk about, well, what do we do with money that has already been paid? Does it have to be refunded? Is the money paid already earned? Do you have to continue to pay what pay out on the rest of the contract, or does it relieve you from the obligations? The contract term itself is going to say what happens in that situation. So all of you that are in one form or another, either hoping that there's a force majeure with the idea to get out of an obligation, you need to look at what your contracts say and how it's written and what happens if this is a force majeure. And all of those out here that are saying, we want the contract to be still in force, we want to get paid our money, also needs to look at the contract and see what it says and what was decided way in advance about this what if situation. Are you still entitled to get paid? Are you, or do you get your money back? Do you have to give a refund? So it really depends. The question of what effect does force majeure have on my productions? It comes down to, what does your contract say and what hat are you wearing? Are you the person that is trying to get out of some obligation, or are you the person that's trying to continue to hold the other side to an obligation? The force majeure language should say it. And you look at the actual words. Generally, force majeure is some event beyond the party's control that suspends or terminates the contract. We didn't really have terrorism listed in force majeure language until after 9/11. Now, typically, terrorism is something that people say, what if there's another terrorist event that prevents a force majeure from being declared? Because prior to 9/11, we just used the term acts of war. And terrorism doesn't fall in the legal definition of war. Or maybe a court would say it does. But to be clear and to make sure both parties have the same understanding of the contract, we started adding terrorism to force majeure clauses. Natural disasters. Everyone understands what that means. Floods, hurricanes, earthquakes. Labor strikes have traditionally been deemed a force majeure event. Acts of God is a term that is often used. Is acts of God the same definition as natural disasters? I know I was a question was raised to me about an actor's equity contract for live stage plays that had to be were subject to shutdown. They couldn't have the theater open. And the theater owner says, the producer says, well, this is a pandemic. It's a force majeure. But Actors Equity says, we don't have force majeure language that covers pandemics. All we have is, we talk about labor strikes, an act of God, and there might be some other language in there, acts of war and acts of God. And they're saying, we don't believe that a pandemic is an act of God. They say act of God means tornado, earthquakes, that type of thing. That's what it's meant. Well, new facts, require new interpretations. If they didn't figure it out, ahead of time that said pandemics is an act of God, there's an argument to be made. Actors' equity says force majeure only applies to acts of God. We don't declare a pandemic as an act of God. Therefore, you need to pay every one of our union members, for what their contract term was. We don't care if your theater's closed. That's the way we're interpreting the contract. My argument is, what are we going to get into a Darwin theory here? I mean, who created the virus if not God? Or as that term is used. I mean, but it really starts to say, well, if you're going to deny God as the creator of the virus, then why are you using the same terminology to say, why are you blaming God for the earthquake, the flood, and the tornado? It could be acts of nature, whatever you want to call it. But with actors' equity, I don't want to get into, are we really going to get into a discussion of Darwinism and the creation versus evolution? I mean, the phrase act of God means stuff that's happening in nature. And whoever you want to consider your God to be, or just evolution as itself, it sure sounds to me like a virus and a creation of a brand new being, entity, whatever you want to call it, a living creature, this virus. Whoever's responsible for creating that, I'd say that's an act of God. You want to say that's an act of evolution? So be it. But your contract says act of God. It applies to hurricanes. It applies to floods. It should equally apply to nature creating this brand new, virus, this living entity that kills people. So that right there shows you how force majeure, it operates, and the arguments that will exist over what does force majeure mean if the parties haven't at the beginning sat out and said, what if? And I can assure you, moving forward, all contracts are going to answer that what if question and have thank you, and have pandemic listed, and there will be a discussion of whether the contract is suspended, whether it is ultimately terminated, and what the obligations are to pay or to get a refund. So to understand force majeure, it is a creature of contract. It begins and ends with what does your contract say, and if it doesn't specifically say pandemic, well, then you have to put your thinking cap on, and you have to make the arguments. And I know that the unions really, they're out to protect their members, and I represent a lot of members that of SAG, of DGA, of WGA, and sometimes I'm representing the production company, sometimes I'm representing the union members, and unions are play a wonderful role in our heavily unionized industry, but they are always out for the best benefit of the union. I know many independent filmmakers will just say, gee, we just took the SAG low budget agreement that SAG puts on its website, and that's what we used. It's got to be good. SAG created it. Well, when you use the contract that SAG prepared and offers for use on their website, you need to understand that's written in a very pro-union and union member way. They're not voluntarily throwing in terms that assist the production company, and they may leave out an awful lot of things that the production company wants, and that doesn't directly relate to the COVID-19 issue, except to the extent that it probably doesn't mention force majeure at all, although the SAG basic agreement does. But it's a good learning lesson for any independent contractor. Don't just simply take the contract that the union posts on its website and expect that that document is going to best protect you. We had a little tussle with SAG about a year ago over their force majeure definitions in their collective bargaining agreement. And what happens when the collective bargaining agreement has a very brief description of force majeure, but industry custom and standards is to recognize a much broader situation of force majeure. Which interpretation governs? And our firm has some great background and history in interpreting the collective bargaining agreements and in making some very persuasive arguments as to how they should be interpreted, and know that it's not just a begin and end all with where the union sees that interpretation, and we have a few cases under our belt that can serve as a good precedent, factored along with the history of the collective bargaining agreement, to argue for a broader definition of force majeure than the unions typically want to give. And as I said, we just saw this with Actors Equity. I understand that the other unions are also taking the very strict party line and saying, if the force majeure language doesn't specifically say pandemic, it doesn't cover pandemic. And again, I would say that that's not where the discussion begins and ends, and it's going to be left for a union arbitration or a court decision that says, what does act of God mean? Is it just natural disasters, or is it also the creation of a brand new biological virus that strickens everyone? And if you have act of God in there, I would stay strong and say you've got a force majeure. But moving forward, I can guarantee you that what if a pandemic arises will be in all future contracts. The SAG is about to go into new negotiations with the Association of Television and Motion Picture Producers. I would bet that the issue of pandemic probably appears in the next collective bargaining agreement. Although sometimes both sides like to leave it vague. Sometimes they prefer to agree just to disagree. So looking at, if you want to apply a force majeure or try to say a force majeure is denied, look to the contract and what the parties anticipated. Now, if you don't have the definition of force majeure that works to your advantage, or if your force majeure language is very limited to certain situations that do not include a pandemic, then look at basic common law principles of contract law. And those involve the doctrine of frustration of purpose, the doctrine of impossibility, or as it's come to evolve, impracticability. And you can also look at certain aspects of the contract that might be able to help you in regards to the boilerplate, where everybody makes a covenant to comply with government regulations. And that can help bootstrap the frustration or impracticability contract affirmative defense or reason for breaching the contract as a justification or excuse when you say, hey, government said we can't work. You told us to represent and warrant that we will abide by all government rules and regulations that affect us. We're just living to the contracts, guys. Give us our money back. Government says we can't work. So if you are in this situation, and I know I've got a lot of questions here about how do I get out of a contract, or how do I stay in a contract, or what are my obligations? Look to the language of the contract. Look first to the force majeure. If force majeure doesn't give you the answer you need, look to the doctrines of frustration of purpose, impossibility, or as it more currently is known, impracticability, and also the covenants to comply with government regulations. And you really need to read every part of the contract and see if maybe something that was referenced in Section 8 is again further referenced in Section 22. Look at the standard terms and conditions and see what you can find to make the argument. We're in a novel situation. It is unprecedented. Perhaps we can go back and look at court cases from 1918 when they had the Spanish influenza pandemic, and much of the same things were occurring. Theaters were closed, restaurants were closed, and find some of those 1918 cases litigated in 1919, 1920, and see what they were doing in these situations as precedent. And maybe it works. Maybe it's only some type of authority because the way the nature of the world has changed, what they agreed to in 1918 isn't necessarily going to be how a court would decide today. But these are the type of things that lawyers are going to look at. We can't just give you a straight answer. When can you ever get a straight answer from a lawyer? But we can tell you the arguments that can be made. And at the end of the day, all of you independent filmmakers really don't have the ability to fight this in court. It's long, it's costly, it's expensive, and the entire court systems are closed down, except for emergency situations, essentially. So we need to look to mediators. We need to have both sides recognize that this is an industry of repeat players. You're going to deal with one another again next year and the year after that. So let's all recognize the world we're in and see if we can meet some type of middle-of-the-road agreement if the contract is not black and white and clear on these issues. Because courts can give a resolution, but once you're in a court fight, neither side really wins. And there are some traditional interpretations that courts apply in interpreting contracts. One such interpretation is interpret against the drafter. So if the studio was drafting the contract, you can say, hey, if it was ambiguous, if it was vague, that goes against you and in favor of me. There are other ways in which courts apply contract interpretations. A lot of times, many of you who have read the standard terms and boilerplates will know that the contract often says, for the purposes of contract interpretation, both sides are deemed to have equally contributed to the drafting. Why is that clause in there? Because it takes out that common law principle of, when it's vague and ambiguous, interpret it against the guy who drafted the language and could have made it more clear. So if your contract has that language that you're both considered a drafter, that's not going to be available to the courts as a means of resolving the dispute. And one other thing that we all have to recognize is courts are not going to be deciding these cases in a vacuum. They can't help but say, how is this decision going to affect the overall economy? What precedent am I setting here? And that might, even if you have really strong arguments to say, heck yeah, this is an act of God, and the force majeure only talks about act of God, and we're now here forced to describe what is or isn't an act of God. You have to recognize a judge, is not going to be deciding that in a vacuum, and he's going to say, is my ruling that it is a force majeure, or is my ruling against it? How is that going to affect the economy? How is that going to affect our nation as a whole? What public policy needs to be factored in? And if people think that was an inappropriate way of deciding, Then they take it up to the Court of Appeals, and the Court of Appeals rules. Again, costly. It's not going to help you get your film in the can. It's not going to help your investors get their money back. So ideally, you're hoping that parties will recognize in this state of emergency that they work together. And that's why I'm really pushing mediation and hoping that if the parties can't meet halfway themselves, perhaps a mediator can help them. We talked about force majeure. No matter how well negotiated the force majeure clause, the other doctrines still exist, and we're going to talk a little bit about those doctrines. And then you have to figure out, are the doctrines only applying on a temporary basis, on a permanent basis? You need to look at the contract and determine, should there be a complete rendering it null and void, or is it the type of contract that can just be suspended and ultimately restarted? Doctrine of frustration of purpose. The classic case on this goes back to England, and forgive me, I don't know which king it had actually applied to, but there was a coronation of a king that was set up, and a traveler in England traveled to London, rented a hotel that had the most beautiful view of the coronation. You'd be able to, see right from your terrace. You could have a glass of wine and watch the king, accept his scepter and be crowned. And you could have a big party there, and everybody, both the innkeeper and the guest, understood that the only reason this rental was occurring was to see the coronation. And the king took ill. The coronation did not take place, and the innkeeper said, "Hey, no refunds, and you still owe us. You gave us a deposit. You owe us the rest of the money." The court said it was clearly known that the only reason they were coming here was for the coronation. The very basic purpose of the contract was frustrated. Therefore, let's make it as if the contract never existed and return the parties to their original position before the contract was entered. That's how the doctrine of frustration of purpose was first invoked in ancient England, and those common law principles were brought into the colonies and ultimately the United States of America. Today, how can we put that same example? You got a hotel room for South by Southwest Film Festival, or you rented a venue to throw a giant party for your film at South by South Film Festival. Those venues in Texas understood that the whole reason for the contract, the whole purpose, was to promote your film at South by Southwest, to have a hotel room for you to attend there. So you could make the frustration of purpose argument regardless of whether the venue had a force majeure clause. And if the force majeure clause didn't go far enough to include this type of event, the cancellation of South by Southwest, you could make the frustration of purpose the common law defense and be entitled to get your money back. If they dispute it, you might have to go to court and get the court to recognize, yes, frustration of purpose doctrine applies here. Doctrine of impossibility, or as it's called today, impracticability, says very much the same thing. There was a change in circumstances rendering performance of the contract literally impossible, or for all reasonable purposes, impracticable to be able to be performed. There's no reason to go on. Frustration of purpose is where both parties fully understood what you were trying to achieve, and that underlying premise no longer exists because South by Southwest was canceled. Impracticability is some circumstance, whether it was foreseen or not foreseen, has come about that just makes it impossible for us to perform. We can't use your stages because the governor of California said all filmmaking must stop. It's not qualified as an essential function. Television broadcasting, podcasting, that's listed as an essential function. That can continue on. But traditional motion picture filming, that didn't make the list as an essential function. So I've rented your stages, and I've had this situation with the client as well, and the stage company said, too bad, we're keeping the money that you gave us. And I had a client that didn't just pay the deposit, but went ahead and paid the full amount well in advance, even paid it sooner than they needed to. And when they said, we're not going to be able to use these stages, the staging company the location wanted to say, hey, that's your problem. We're going to keep the money. Now, we made some persuasive arguments, and we got it to happen. And fortunately, we got people to agree, and they didn't, the threat of a lawsuit, the threat of a class action lawsuit can get things done. Especially when you're telling the other side, look, I don't care about the 50 other people you're screwing over, at this time period during these rentals. I just care about the client that's my client that's retained me. So if you want to have a confidentiality agreement and give us our money back and treat other people a different way, I'm just here looking out for my guy. But if you don't want to make that agreement, I'm happy to take on a class action and, look out for everybody else. And I think I noticed at some point that one of America's foremost class action attorneys is listening in today. So I hope he approves of how I just phrased that, and maybe even gave him some ideas on how he can help members of our industry. So the doctrine of impracticability, it's just, I can't perform. And again, sounds an awful lot like force majeure. Circumstances beyond our control, but force majeure is a contract term. Impracticability is a common law principle. Okay, and that allows you to be legally justified to not go further with the contract. And again, these are arguments that can be brought up when the union is very forceful and saying, we need all of our employees to be paid. We talked also about the government regulations. Isn't it, every contract generally says, you represent and warrant that you'll comply with all regulations, laws, statutes, etc. Usually the other side that's putting it in there, that's a restriction on you. That's for their benefit. But you can turn that around to your favor. And you can say, hey, you told me I had to comply with the government regulations. I'm complying with the government regulations. My purpose has been frustrated. It's impracticable for me to go forward. Let's nullify this contract and give me my money back. Insurance. Every filmmaker, again, I think this pandemic is going to teach the guerrilla filmmakers that, I'm all for, guerrilla filmmaking, except where it jeopardizes the investor's money, jeopardizes the safety of your actors and crew on the set, and those are pretty much the two times that I really say, you can't go guerrilla on this. And jeopardizing the investor's money also includes misclassifying employees as independent contractors, or not complying with government rules of having workers' comp insurance, or or even to not have the most basic insurance that a prudent businessman, a prudent producer would have on their film. And you all should at very least have general liability insurance. That stuff that covers if there's a slip and fall. As I know, I'm in a pretty nice office. It's kind of a little messy here in my back. I was hoping to have my artificial green screen behind me, but we were having some technical difficulties today, so we didn't get that up. But as part of my lease, I'm required to have a general liability policy that lists my landlord as an additional insured. And it only costs $500 a year. Nobody's getting injured in a law firm. No one's tripping and falling in my hallway, hopefully. And if I'm the lawyer, they'd call in case they did. Hopefully that renders that not too much of a problem. But we have insurance if it happens. And what I found out is every basic general liability policy also, pretty much more often than not, they include a clause that talks about business interruption insurance. Now, albeit, I think that was developed when they had these what ifs. They were thinking the what ifs of business interruption is, there's an earthquake or there's a fire and people can't get access in and out of my office, and that causes a close down. But just because that is what they may have been thinking in their head when they drafted business interruption, unless the insurance carrier had the foresight to say pandemic is not included in business interruption. We are talking about physical damage only to the property that causes a business interruption. If the contract is not that clear, your simple basic general liability insurance, which for my law firm is only about $500 a year, and we've had it for 20 years and never filed a claim, it's going to be hard for the insurance company to say the pandemic is not a business interruption. And courts historically, particularly with insurance contracts, interpret it against the drafter and in favor of the insured. Now, might a judge consider the public policy that a ton of insurance companies might go broke because of this if they take that interpretation? And if the judge has a political leaning one way after another, maybe. Maybe they take a stricter interpretation and say, no, it's only physical damage. Maybe the contract itself even says business interruption applies to physical damage. I have a client that wants to get out of a box seats at a for season tickets. Circumstances change. They can use every dollar. Plus, who knows whether the games are even going to be played. And this particular contract, it has a force majeure language, doesn't talk about pandemic. It talks about if your seats are unavailable because of and it mentions physical contamination. And it says, well, I guess like if there's asbestos or if the fire's destroyed your seats, they can put you in another seat in the stadium. And if the entire stadium is closed, then in that situation, you can get your money back. Well, I think the way contamination is used, that you don't have to be so myopic. You take the broad, interpret it against the drafter. And why aren't people allowed in the seats? Because of a fear of contamination, because this virus might be there at the seat. And I think there's a strong argument that the reason I can't use my box seats has to do with contamination. And therefore, I should be able to invoke that provision and get a refund on my box seats season tickets. If they say no, well, then we're going to have to take this to court. I know, again, hoping that my friend, the America's greatest class action attorney, is listening in. You can be damn sure that I'm going to threaten. Settle up my guy right now, because this is all I care about. He's my client. But if you don't, I'm not going to bring this to court just for him. I'm going to bring it as a class for every season ticket holder and every box seat holder. So wouldn't it be better to give my guy the money back and us sign a confidentiality agreement and we go on our merry way? Hopefully that's going to be the resolution. So look at your general liability policies. You could also have more exotic policies. And again, you only get one chance for the pandemic to occur. The pandemic only occurs for the first time once. I always tell my clients you get one chance to make a first impression, so make sure that script is in the best possible shape before you start shopping around. Well, you only get one chance to claim it's ambiguous as to whether pandemics apply or not. Because I assure you, every insurance policy moving forward is going to expressly exclude pandemics unless you pay extra for that coverage. And with insurance, you can insure everything. It's just a matter of how much extra cost will be in it. Same thing goes with those of you that have a completion bond. And if you're an independent filmmaker, anyone that is making a movie over $1 million, you should have a completion bond. I have a whole separate discussion on that. You don't just do it simply, oh, well, we have a bank, so we need to have a completion bond. If you have private investors and you're taking more than $1 million, the reason lenders require completion bonds is because it's the smart move. It's a hedge in the bets to protect their investment. And every producer should first and foremost be saying, how can I best preserve my investors' money so they'll come back again? Far too many producers just care about the cash grab. They don't care about their investors, and it drives investors out of this industry. There's another one we lost. You should have had a completion bond. Well, you didn't. Those of you who did, I can bet you the completion bond company failed to say, what if a pandemic? And so they are probably on the hook to finish your film, get it in the can, and pay whatever cost overruns are tied to it. But I promise you, if you start a film as soon as this government section is lifted, this government restriction is lifted, and you go to get a completion bond, they're going to exclude pandemics from that coverage. Or you're going to have to pay extra for that, and you'll probably have to pay through the nose. If you're a concert promoter, things like that, I know I'm mostly talking to film producers here, but there is event cancellation coverage. Again, you were supposed to go to South by Southwest. Maybe you took insurance out because for this big giant party you were going to throw. You probably had event cancellation coverage, but if you look at the language, it was probably talking about weather. If the event rains out, you're putting on a giant corporate, your corporation's putting on a giant day at a golf course. The firm founders day, and we're bringing everyone in, we're bringing salespeople in from across the country, and we're going to have this big golf outing. And you pay to have the entire golf course all to yourself. You probably have event cancellation coverage, but that insurance is probably talking about rain. Got to look at the policy. Can we make a clever argument that pandemic also applies? Okay, so that's how we deal with your businesses in terms of trying to get out of contracts. What about can I go forward? A lot of people say, can I go forward with filming? You have to take a look at your jurisdiction's definition of what essential service exemptions are. In California, television broadcasting, podcasting, those are essential services. But traditional motion picture filming is subject to the shutdown. We've talked about insurance issues. Know that the famous restaurant French Laundry, they have already filed suit for declaratory relief against their insurance company to deem that the pandemic falls under the property damage from the virus. That because the virus, why is our place closed? Well, because the virus might remain on the door handles, the tables, the chairs. Just like the virus might be on the seats in the stadium. Therefore, we are talking about property damage in the insurance company because the insurance provides only for loss caused by property damage. We'll see how that case progresses on behalf of French Laundry.
And we are about to reach the end of our stream. Maybe we give it 5 to 10 more minutes. Questions.
For 5 to 10 minutes, let me hit some of the questions that were put in advance. I think I covered a lot of them through this subject. Let's hit some insurance and liability questions. Any possibility of insurance protecting a shoot that has been indefinitely postponed rather than canceled? Again, look at your policy, look at the business interruption insurance. Can production be held liable for crew or castmate contracting coronavirus in the future? Would the production be in danger of liability if the film shoot is conducted during the stay-at-home orders? Well, yeah, if you're in violation of government rules, then you're probably going to be liable for any damage that comes from you shooting in violation. Don't go guerrilla. Also, there is a general rule for all producers to make sure that the general OSHA rule, there's a duty of safety to all your employees. OSHA Rule 5A1 says that the employer has an obligation to provide a safe workplace free of hazards. And that would include the coronavirus. Walmart is being sued right now for a couple employees that contracted the virus while at work. Normally, if you've done everything right, and particularly if you didn't foresee this and the rules haven't come out, right now we just have the basic general OSHA rule. Provide a safe workplace. I can guarantee you in 6 months, OSHA will have regulations concerning what that means to prevent a pandemic. And we're going to be in a much different world. Producers are going to have to understand that, and they're going to have to comply with it. If they don't, they can be subject to liability. Make all of your cast and crew employees, if they are injured on the set due to illness or a boom hit them in the head, they are subject, if they are your employees, to the exclusive provisions of workers' comp. And their remedy is to file a workers' comp claim. And that's covered by insurance, and you don't have to go to court. And the liability is limited strictly to what the actuary tables and the workers' comp court system says it is. That's a very nice thing. That is a reason why producers should comply with the laws on properly designating people as employees rather than independent contractors. If they're an independent contractor, they're outside of workers' comp and they can sue you in court. Do you know if we can make an insurance claim, and how does force majeure fit in? This is someone that I was 2 weeks into shooting my film, and I had to take a pandemic pause. I only had 4 days left of shooting. Again, we talked extensively about force majeure. We talked about how you can make an insurance claim. Can we make an SBA claim? Okay, there are two. Go to SBA.gov. In particular, go to the website COVID-19 relief.sba.gov. And you can see the ever-changing, constantly evolving programs that are in place for small businesses during this pandemic. The PPP, the Payroll Protection Program, is, if you haven't applied, apply right away, because that $200 billion or $350 billion is going to go quick. Every banker says that. You have to contact whatever bank you regularly work with. You fill out the application. I did it for my firm. It took me about 8 hours to gather all of the different payroll reports and things they want. Still not that great of a time chunk to get this process going. You apply, you get 2.5 times whatever your payroll, your average monthly payroll is. You can use that money to pay wages. You can use it to pay rent and utilities. And utilities, arguably, again, the rules kind of might change, but I believe utilities include, and others believe it as well, cell phones and internet service for all your people working remotely. And if you use it for rent, utilities, and salary, it's completely forgiven. 2.5 times your monthly wages. Government's just going to give you that money. If you use it for something else, you don't have to pay it back until a year from now, and it's only 1% interest. There is also the economic injury. Let me get this right. What is it? The EIDL stands for Economic Industry Disaster Loan Programs. This is something that's always been in place for every disaster, state of emergency. It applies to this pandemic. You can get up to a 30-year loan. They've relaxed the rules for the pandemic. Go to the SBA website. You can figure out the application. That is one that you don't need to go through your private bank to get. The PPP, you work through a private bank. The basic economic disaster loan, that you apply for directly on the SBA site. It'll take you about 2 hours to fill it out. You can get up to $200,000 without having any personal guarantee. I think they require some collateral, but it's if you go above 200,000, I think they require something, but it's just your assets. The granting the loan is based just on a credit check, on what your credit score is. Very simple. It's a loan, no repayment, I think, for a year. Then you have 30 years to pay it back at 3.75% interest. So, and there's also the first 10,000 can be forgiven if you didn't apply for the PPP program, and you can show you get 1,000 forgiven for every employee that you keep on your payrolls. Again, the specific rules are at the SBA website. If you need help, you can call me. We can work through that stuff for you if you want to retain our firm to do that. But most of you should be savvy enough to follow the rules. And that is that program. There's a lot of money there, and I encourage you to look at that. And the payback, you can really push that out at a low 3.75% interest over 30 years. What legal means can we assure our insurers for our production so that we can have permission to shoot again? If we do get insurance, what liability do we run from a crew of 10 or less observing the government guidelines? How will the pandemic affect future productions and event insurance? Again, the contracts are going to govern. If you have insurance currently in place, I think there's a lot of room for vagueness and ambiguity to be argued, and to look at what the contract is, to consider some of these common law provisions. Moving forward, the insurance company is going to price the risk. I'm the head of a production company in New York City. My biggest question is the legal ramifications. Are we technically allowed to do production as long as we keep crews down to under 10 people? You got to look at your basic jurisdiction on what the essential job functions are and whether you can. Even if you can, should you? Do we want to be good citizens? Is it now is the time to take the break, focus on development, focus on your post-production. Do you really want to put people out there? Do you really want to jeopardize your crew, even if they are 10? Again, you have the basic OSHA safety rule: provide a safe workplace. That can be that's going to be interpreted in a very paternalistic, protectionist way. And by all means, make sure you have workers' comp and make sure that they're employees and not independent contractors, and see what tomorrow brings. But we're only making movies here. Is it an essential function? Is it better just to wait? And this is coming from a guy who's a movie guy. So lost my investors. What's the best way to proceed in this climate? What if my production decides to start filming with a skeleton crew and one of my PAs gets sick? We've discussed this. It's a brave new world. Watch out for the OSHA general rules. We are moving into recession. A lot of people want to know, what's my crystal ball say about film investments? A month ago, money was free and easy. There was a lot of money available, people looking to make it a place to invest. How will investors react when we wake up from this? Filmmaking has always been inherently high risk. High risk, low reward. That's what you should be telling your investors. I've never met an investor that only wanted to invest in films because they thought that was the best way for them to make a lot of money. They don't want to lose their money. They realize it's volatile and there's a risk, but they're always in it for this other opportunity. It's fun to be at a cocktail party and say I invested in a film and talk about what the film is. It's more fun to say that than I invested in, some manufacturer that makes cogs for something. I want to be on the set. I want to go to the premiere. I want to see my name on a movie screen. Those are the reasons people invest outside of the pure financial reasons. Will those other reasons be outweighed on the scale when money becomes tight again? Sure it will. But there's always going to be those people. And once our society, our economy gets going again, hopefully people will return to this. Let your investors know you care about them. Let your investors know what you're doing to protect their money. And know that no investor is making an investment in the film strictly because they think this is the best place to make the most money for their money. They're putting it in because they want that other experience. That's what they're investing in. And you want to make sure that they get that experience in a very positive way. SAG-AFTRA is asking me to pay all of my actors even when we hadn't even had a rehearsal or any contract signed. We're working on a low modified budget. Is there something we can do to save our project? Wow, no contract signed. There's a situation where the agents got a little too smart for themselves, right? We know traditionally artists, they're always trying to make an excuse not to sign their contracts. And we're always telling the producers, get everyone to sign it. Just get them to sign it. Yes, the unions are taking hard lines. Everyone deserves to be paid. This isn't a force majeure. To paraphrase, in a primetime audience, Ray Liotta from Goodfellas. F you, pay me. Your restaurant burned down. F you, pay me. You got a strike. F you, pay me. Right? That's the way the mob was when they went to business with the restaurateur. Yeah. Unions want to see their employees paid. And of course they're going to take that hard line. But they're just because they say that's the position doesn't mean that's where the law is going to come down. And again, everyone needs to remember we're repeat players in this. Everyone needs to cooperate. Let's live and play another day. But if you're whoever has the union issues, we do a lot of work on behalf of production companies with unions, and we have addressed the force majeure problem in the past, and it's something they like to dispense with and not have any precedence on the plate because they like the grayness that's tied to it. They might not be able to get there now with this. There might have to be something that goes on the record, an actual arbitration decision, an LRB decision that that all the world can see. Independent contractor, what can I do? Well, if you're an independent contractor, you can apply for the PPP program. Again, if you have some payroll, go check out what the rules are. You're definitely entitled to the economic injury disaster loan program. And if you're in California, they changed the rules to allow independent contractors to apply for unemployment. So you can get unemployment benefits even if you're an independent contractor and you're in California. If you're watching this in another jurisdiction, check with the laws of your jurisdiction. But that was a change that the governor made in light of this COVID emergency. Independent contractors can collect unemployment. You can register it online and do it sooner rather than later because those websites keep crashing as more and more people keep using them. Production was about to start April 3rd for 27 days. Low budget of $75,000 for crew. We dispensed no payroll in the prior year. Can we still benefit from the PPP? No, it's based on your payroll amount. Can we benefit from the Economic Injury Disaster Loan Program? Yes, you can. And go to the Small Business Administration and learn how that works. Film was about to show at a major festival and was canceled. I don't have production insurance, and I treated everyone as an independent contractor. Well, that's tough because regardless of what jurisdiction you're in, a lot of those people that you treated as independent contractors are actually employees. And if any one of them files for unemployment, that is going to reveal that your company failed to properly enroll them in unemployment. And that can subject you to a lot of fines and a lot of penalties. And they're really strict with that. And you can be sure with the debt that the government is going into, they're going to be looking to get that money back and find the people that are operating specifically outside the law and treating everybody as independent contractors. Okay. Even before AB 5, if you're in California, most crew positions were that of employees, not independent contractors. And I've been preaching this for 20 years. And I would always see, even in the best of times, a producer that failed to follow our advice get caught up in an unemployment claim because someone filed for unemployment. They were treated as an independent contractor. Unemployment recognizes them as an employee. They see they're not on your list. And then the fines and penalties come in and they want to see all of your books and they open up and they say, who else did you misclassify? And in California, the penalties for intentionally misclassifying someone as an employee instead of an independent contractor is astronomical. It's astronomical, the amount of fees that they can impose. And it's also criminal liability as well. Nobody in the year 2020 should just be electing to pay their whole crew as independent contractors. The risk is just too great. It was too great in January before the pandemic, and now the chickens are coming to roost. It's going to be you're just going to have to plead to the mercy of the government regulators that may ultimately come knocking on your door. The law determines who is supposed to be treated as an employee and who is supposed to be an independent contractor. Even before AB 5, all ties go to the finding of being an employee rather than an independent contractor because that helps the state pay their unemployment insurance. So if you're in a tough situation, I don't mean to scare you, but you should consult with a lawyer in your jurisdiction. And please, everyone should, treat this as, this is a gut check. We're not just putting on a little show in our backyard. I know it feels that way when you're an independent filmmaker, when you're guerrilla. But the state in which you reside and the federal government sees you as an employer of 50 or more employees when you add up all of your cast and crew. And you have to comply with labor and employment laws. You have to comply with security laws and how you have your money. And there's just prudent ways of doing business. You need to have insurance. And if that means you have to raise a little bit more money, you need to do it. Let me just see if there's a few more things. I know we started about 15 minutes late, so I want to. I have a digital branded content project in post. Halfway through delivery, the brand disappeared. What's the best way to collect the remainder of the budget since 50% is due upon completion? Should I just send over the deliverables so we've completed our end of the agreement and bill for the rest? Yes. I don't know what disappeared means. I take it they're trying to claim they're out of the picture. They're trying to assert a force majeure. Again, look at your contract. But if it doesn't, this is a situation where you're the guy who doesn't want the force majeure to apply. So look at the strict language of the contract and who wrote it. Did they write it or did you write it? And by all means, live up to your obligation so you can say, we abided by our contract, we supplied everything, and then you might have to go to court to get your other 50%. And I don't quite know what disappeared halfway through means. I mean, it probably assumes they're just trying to disavow the contract. Is there a way to get payroll loans for paying independent contractors working for us? The PPP includes not only your paying employees, but independent contractors. So you might get screwed on the unemployment findings, but at least you can get the money on the PPP and that's included in payroll. Will private individual investors be looking to finance in the near future? I answered that question. People don't invest in movies for the financial return. They do it for the extra fun that's involved in the movie business. Is that going to be outweighed if they have to watch their wallets? We'll see what happens. It's going to be tougher to get a completion bond. Completion bonds are going to exempt pandemics. You can be sure of it, or you're going to have to pay extra. You can get anything covered from any insurance. You just have to pay higher premiums for it. Talk about AB5 and the pandemic. For those of you who don't know, in California, effective January, the state has a new way of classifying who's an employee and who's an independent contractor. It replaced the time-tested Borello test, which was a whole bunch of factors to determine whether this person was really acting as like a separate little company working for you, or whether it was more like did it seem more like an employment relationship. Part of the Borello test was always, are they a essential function of production? Meaning, is this someone that's kind of ancillary? You can make a movie without a lawyer. I wouldn't recommend it, but it's not an essential function of the production. Therefore, that bodes towards being an independent contractor. And there's a lot of other reasons as well. We're licensed and all the other things. We use a lot of our discretion, and we work for other companies. We're not exclusive, etc. But even under that Borello test, it was always very difficult to say that a lighting guy or a grip was anything other than an essential function of production, and not having a lot of discretion, and had to be working exclusively for you during the time period, and listening to a supervisor that tells them exactly what to do. in those situations, rank and file guys, they never were going to pass an independent contractor test, even under Barella. And they certainly weren't ever going to be ever forward under AB5. People are saying, can we petition California to make AB5 revoked? That's not going to happen given the political culture of this state. I have been actively lobbying on behalf of certain sectors of the entertainment industry to get exceptions recognized to AB5. And we've been very successful in moving that in that direction, but based on specific facts, specific jobs, and legal arguments that can be made with that. But it doesn't work with a broad brush swoop for everybody. And anyone that thinks California is going to revoke AB5 in its entirety, you're just wrong. There are ways to treat that. There is a way to be still paying a loan out company. I completely disagree with commentators that say AB5 is the death of all loan outs. There is a logical legal way to address loan outs, and we can help put that type of provision in place for you if that is something that you're looking to do. In which case you're still going to be subject to employment laws, but it just involves a very carefully documented understanding of joint employment rules and regulations, and understanding what you are not excluding yourself from being involved with. But AB5 is not the death of loan outs. The folks that wanted some clearance questions, I invite and encourage you to send an email to me, David at piercellp.com. That's PIERCE LLP as in partner.com. And we can talk offline about subjects that, such as, clearance issues that don't really involve the COVID-19 stuff. If you go to piercellp.com, or piercelawgroupllp.com, takes you to the same place. Visit our info center, and you can see some blogs that we've written. We have a new post up called The Independent Gig Worker's Guide to COVID-19. This virtual legal clinic will also be available on our website, and will be available via Slamdance and Movie Maker magazine, and it'll be turned into a podcast. We will most likely have future follow-ups on this as well. And if you have further questions, write them in. We'll try and get them answered next time. I believe I have addressed all of the questions that came into me, either in that last section or through the course of me talking about these unique issues. I hope I answered a lot of questions. I probably raised a few additional questions, and I invite and encourage you to contact me, and someone from my law firm will get back, and we can provide you more specific questions that you may have. It's tough going. We're all in it together. I want everybody to be safe, shelter in place, know that there is going to be a day when filmmaking, comes back, and the world is going to need entertainment, and Netflix and all the rest, they're still going to need content. So once we get back, I think we're going to go into overdrive and see a lot of productions back in place, and maybe they're going to find those investors that still want to put in money and have that money, and be honest and upfront with your investors. If you have investors now in your places, now is not the time to run from the investor. Now is the time to make a personal call and to send emails and let them know what's going on. I've never seen a situation where an investor sued because they lost money, because of circumstances beyond the producer's control. What they get sued is bitterness gets companies and producers sued. When you run away and you're afraid to tell the investors about the bad stuff, that's when they get pissed off. And that's when they talked to a lawyer, and the lawyer said, these people never complied with security laws. We can go after them. So when times are bad, that's when you most want to be in touch with your investors, reassuring them in a truthful way. And we're all in this together. Thank you so much for tuning in. I encourage you to send emails with your comments, or post the comments in the chat section here. I'd love to hear what people think. And if there are any attorneys that are listening in today, if you send us a separate email and you're a California jurisdiction, you can get 1 hour CLE credit. We are a certified CLE provider. And just shoot me a separate email to that event, to that aspect. And I thank you all. Again, be safe and remember to wash your hands.